3, 2, 1, start. Having analyzed the circumstances which were relied upon by the state of Arunachal Pradesh, we are of the view that in running the hospital, Ramakrishna Mission does not discharge a public function, full stop. Unfortunately, the hospital is in receipt of some element of grant, full stop. The grants which are received by the hospital cover only a part of the expenditure, full stop. The terms of the grant do not indicate any form of governmental control in the management or day-to-day functioning of the hospital, full stop. The nature of the work which is rendered by Ramakrishna Mission, in general, including in relation to its activities concerning the hospital in question is purely voluntary, full stop. Before an organization can be held to discharge a public function, the function must be of a character that is closely related to functions which are performed by the state in its sovereign capacity, full stop. There is nothing on record to indicate that the hospital performs functions which are akin to those solely performed by state authorities, full stop. Medical services are provided by private as well as state entities, full stop. The character of the organization as a public authority is dependent on the circumstances of the case, full stop. In setting up the hospital, the mission cannot be construed as having assumed a public function, full stop. The hospital has no monopoly status conferred or mandated by law, full stop. That it was the first in the state to provide service of a particular dispensation does not make it an authority within the meaning of Article 226, full stop. State governments provide concessional terms to a variety of organizations in order to attract them to set up establishments within the territorial jurisdiction of the state, full stop. The state may encourage them as an adjust of its social policy or the imperatives of economic development, full stop. The mere fact that land had been provided on a concessional basis to the hospital would not by itself result in the conclusion that the hospital performs a public function, full stop. In the present case, the absence of state control in the management of the hospital has a significant bearing on our coming to the conclusion that the hospital does not come within the ambit of a public authority, full stop. Para, it has been submitted before us that the hospital is subject to regulation by the clinical establishments within bracket registration and regulation act, 2010, full stop. Does the regulation of hospitals and nursing homes by law render the hospital a statutory body, question mark. Private individuals and organizations are subject to diverse obligations under the law, full stop. The law is a obliquous phenomenon, full stop. From the registration of birth to the reporting of death, law imposes obligations on diverse aspects of individual lives, full stop. From incorporation to dissolution, business has to act in compliance with law, full stop. But that does not make every entity or activity an authority under Article 226, full stop. Regulation by a statute does not constitute the hospital as a body which is constituted under the statute full stop. Individuals and organizations are subject to statutory requirements in a whole host of activities today full stop. That by itself cannot be conclusive of whether such an individual or organization discharges a public function full stop.